Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco Lloyd, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host a FedSoc Forum webinar on the free exercise of religion and abortion, featuring Erin Hawley, Michael Helfand, Jesse Hill, and Sharif Girgis. Our moderator today is Dr. Michael Moreland. Dr. Moreland is a University Professor of Law and Religion and Director of the McCullen Center for Law, Religion, and Public Policy at Villanova University. In the interest of time, I will not read his full list of accomplishments, but if you'd like to learn more about Dr. Moreland and all of today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Professor Moreland, thank you for joining us today, and the floor is yours.
Thank you, Marco, and thanks to the Federal Society for sponsoring this webinar on this timely issue of free exercise and abortion. In the wake of the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization in 2022, pro-choice advocates have argued that restrictions on abortion violate freedom of religion in some circumstances. A recent decision by the Indiana Court of Appeals, academic articles, and media stories have taken up these religious free exercise challenges to abortion laws. This panel will explore the constitutional and statutory grounds for these claims in different faith traditions, pro-life responses to them, and the implications of these claims for religious liberty and for the post-Dobbs legal status of abortion. As Marco mentioned, in the interest of time, I won't give long introductions to our very distinguished panelists. You can see their full bios on the webpage for this webinar. I'll introduce them in alphabetical order, and then we will start an initial round of questions that will take us through at least roughly the first half of the hour or so. And then we'll have some time for the panelists to engage with each other, and then about 15 minutes at the end for questions and answers from you, the audience, which you are welcome to submit through the Q&A function at the bottom of the Zoom window. Yeah, I'll remind you again at around 1:15 or so, but you're welcome to submit questions throughout the webinar as we go. So to introduce our panelists today, Sharif Girgis is Associate Professor of Law at the University of Notre Dame Law School. Erin Hawley is Senior Counsel and Vice President of the Center for Life and Regulatory Practice at Alliance Defending Freedom. Michael Helfand is the Brenden Mann Foundation Chair in Law and Religion and co-director of the Nootbaar Institute for Law, Religion, and Ethics at Pepperdine Caruso School of Law. And Jesse Hill is the Judge Ben C. Green Professor of Law and the Associate Dean for Research and Faculty Development at Case Western Reserve University School of Law. So I thought we would begin with you, Jesse. Many people on the webinar and who will listen later are probably familiar with these claims, but a lot of people probably aren't and are maybe wondering what is the interplay between religious free exercise and restrictions on abortion. So maybe you could kick us off by saying a little bit about the nature of these claims, their basis in either constitutional or statutory law, and why you find these claims plausible.
Sure, thank you. I'd be happy to. So yeah, there's currently litigation sort of post-Dobbs that has been brought in a handful of states by individuals who claim that those states' abortion bans violate their religious freedom. The main states in which there's three main states in which the litigation has been really active: Indiana, Kentucky, and Missouri. There are also claims that are part of broader lawsuits in Wyoming and Utah, and there were a couple of cases in Florida that were later voluntarily dismissed. But in the states where the litigation is active, all of those states have bans on abortion from conception forward, with very limited exceptions for certain circumstances. And I'll say more about that in a minute. But the plaintiffs in these cases are, as I mentioned, sort of largely individuals, some religious groups, some religious leaders. Most of the plaintiffs are Jewish. Some also belong to Protestant groups. And their argument is that the state abortion law bans abortion in circumstances in which they are compelled religiously to seek an abortion. Well, that's one set of arguments. So the main one. So in other words, that, for example, they may be compelled to seek abortions to protect their health when their health is at risk, or in cases of severe fetal anomalies where they're incompatible, with life after birth, for the fetuses have these anomalies, that perhaps that they are religiously compelled to seek an abortion, but that there is no exception for them under the state law. There's also the Kentucky case has taken a slightly different turn. The plaintiffs claim that they are religiously compelled. They're Jewish plaintiffs that say they are religiously compelled to procreate or to try to procreate. And they claim that this state abortion ban actually inhibits them from using in vitro fertilization to accomplish that, and that that's the only way that they can procreate. These claims are made under state constitutions, but basically in state law. So state constitutional equivalents of the federal free exercise clause, as well as the state equivalent of the establishment clause. And then some are also made under state equivalents of the, state versions of the federal Religious Freedom Restoration Act, or RFRA. These cases have been a bit of a mixed bag in terms of outcomes. And I also don't want to sort of dig too deeply into the sort of ins and outs of the various cases. I just want to sort of take a few minutes to give the big picture of, what do these claims look like, and how do they proceed sort of generally, and also not just talking about the litigation that's currently pending, but also what have scholars sort of said, what kinds of arguments have they said could be made, because these are, this is all still kind of in motion. There are lots of ongoing developments in this area. So I want to spend the rest of my time just talking sort of generally about what religious freedom claims challenging abortion bans kind of look like. And I'll just note, I said in passing, there are also establishment clause type claims. I'm not going to talk about those right now because that's not as much the focus of this webinar, but we could certainly come back to it if folks want to. So under the federal free exercise clause, the Supreme Court has held that if a law is neutral and generally applicable, their plaintiffs are not entitled to a religious exemption from that law for religiously motivated conduct. However, what constitutes a neutral and generally applicable law in the Supreme Court's doctrine has kind of gotten narrower and narrower over recent years, such that at this point, essentially the rule is if a law makes almost any exceptions for secular conduct, that equivalent religious conduct, religiously motivated conduct, must be also exempted from the law, unless the government can satisfy strict scrutiny. In other words, unless it can show that the law that it's trying to enforce advances a compelling government interest by the least restrictive means available. Under the Religious Freedom Restoration Act and state equivalents of this, the analysis is more or less the same in terms of strict scrutiny, except that the only showing the plaintiff has to make initially is that the state law substantially burdens their religious exercise. And then if it does, strict scrutiny applies. So basically the outline of the claim is, again, that the state abortion bans violate individuals' religious exercise. And I'll note, as I said before, in some cases, the claim has been that plaintiffs are religiously compelled to seek abortion in certain circumstances where it would not be permitted under state law. However, that is not the only kind of claim you can make. Plaintiffs can also make a claim that they are religiously motivated to seek an abortion, or that they are religiously compelled or motivated to provide an abortion. So we haven't seen provider claims being brought, religiously motivated providers, but that is something we may see in the future. But also, I just want to be very clear that there is nothing in free exercise doctrine or in RFRA, and actually there is specific language in RFRA that says that the religious exercise that the plaintiff is engaging in does not have to be compelled by or central to the plaintiff's religion. So, it becomes then a question of whether this is religious exercise at all, I think. Seeking an abortion, Religious exercise is, again, very broadly understood in general under the case law. It certainly includes conduct that is not, that extends well beyond sort of worship and things that look like religious rites and rituals. Certainly if, refusing to participate in abortion, avoiding vaccination and so on is religious exercise. Seeking an abortion, providing an abortion can also qualify as religious exercise if it is religiously motivated or compelled conduct. And then finally, and I'm already almost out of my time, so I'll just say the question then becomes whether these statutes can meet strict scrutiny. Often, and this also goes to the question of whether they are neutral or generally applicable. Every state abortion ban at least has an exception for abortions that are necessary to save the life of the patient. Many of them also have other exceptions that include health of the patient, but may be more or less narrow. Some, like Indiana's, include exceptions for rape and incest in certain circumstances. Virtually every state that has an abortion ban, I think, also allows for the destruction of embryos that have been produced in the context of in vitro fertilization. Many of them, most of them also accept ectopic pregnancies, and some accept lethal fetal anomalies. So, if the state's claim is that it has a compelling interest in life from conception forward, or that it designates personhood as beginning at conception, and that it has a compelling interest in that person, the life of that person. The claim for folks who are challenging these bans is basically that the wide variety of exceptions, or at least the existence of even one or more of these exceptions, very much undermines the idea that the state cannot then turn around and also, or that the state has a compelling interest in life from conception forward, and that it cannot exempt religious individuals if it can exempt individuals in these other circumstances. So didn't really touch on least restrictive means. We can talk about that if we want, but I will stop there so that I don't speak too much longer.
Thank you, Jesse, very much. I'll turn now to Erin Hawley to offer a response and perhaps continue filling out for us how these kinds of claims brought against abortion restrictions map onto the contemporary free exercise jurisprudence involving both RFRA as a statutory matter and also constitutional First Amendment free exercise doctrine. Erin?
Sure. Thank you so much. And thanks to FedSoc for having us to discuss this really timely topic. And the first thing I would like to note is that this is not something that is entirely new. I sort of come at this as being a novel new argument that's being raised post-Dobbs. And it is certainly true that this sort of litigation and these sorts of First Amendment claims have been brought to a head by Dobbs. But in 1968, for example, Professor Roy Lucas argued, this is detailed in a recent Heritage memo, that prohibiting abortion may interfere with a woman's right to act on her belief that a fetus is equated with a human being. So in other words, the professor argued that because of a belief that a fetus is not necessarily a human being, that prohibiting abortion would interfere with a woman's right to choose abortion. And in addition, in Harris versus McRae, the plaintiffs there raised a host of claims in challenging the Hyde Amendment. One of those was a free exercise challenge. And so the playing field is not exactly new, but it certainly has changed, as Professor Hill noted, as the Supreme Court has been increasingly protective of religious liberty. So to dive, sort of continue the conversation, respond a bit, and to dive more deeply into each of the claims that plaintiffs have raised here. The first thing I wanted to note is sort of a threshold issue, is that as in every case, Article 3 standing must be satisfied. This, I suspect, will prove a hurdle to many plaintiffs who are seeking to challenge abortion laws based on what they say are their religious beliefs. In the Indiana case, for example, you had plaintiffs who, vaguely gestured to the idea that they might like to have children someday, but couldn't, couldn't engage in relationships because they were worried that they might have a condition that would threaten their health at some point in the future, and that the state law would prohibit them from having an abortion, even if that abortion was consistent with or compelled by their religious beliefs. So needless to say, that is a long chain of circumstances to find injury. So I think that will be a threshold hurdle for a number of these claims. But putting to one side standing for one instant, I wanted to talk a little bit about free exercise, a little bit about RFRA, and then finally a little bit about this Establishment Clause claim. And the Establishment Clause claim is actually getting a lot of attention, especially in the academic literature. And I suspect the reason for that is that an Establishment Clause claim would not just be an exception from a state's law, but would in fact invalidate it. So if the purpose of these challenges is to invalidate state laws protecting life, then the Establishment Clause accomplishes that purpose much better than does a free exercise challenge. So to start with the free exercise challenge, Professor Hill mentioned these. This is the bulk of cases that have been brought under challenging state pro-life laws. Of course, we know, to sort of take a way step back, we know that the First Amendment prohibits laws respecting religion. In Sherbert versus Verner, the court had a test that said when an individual has confronts a state or local law that forces them to forego a religious observance, then the burden has been placed on their religion, and that is subject to strict scrutiny. Smith, of course, made that test much more difficult. What Smith said is that a law that is general and neutrally applicable does not violate religious liberty. So that left sort of two lines of challenge open to religious adherence. One of those was to show hostility. So if you think of cases like Lukumi, in which the locality had targeted particular methods of slaughter based on religious beliefs, or if you think of cases like Masterpiece Case Shop, in which the state of Colorado had targeted Jack Phillips, those are the sort of religious hostility or targeting claims that survive Smith. In addition, as Professor Hill mentioned, the Supreme Court has broadened, or maybe I should say narrowed, the generally applicable part of Smith. In the case known as Fulton, the adoption case, the court determined that where a state law or local law has exceptions that permit sort of arbitrary or discretionary enforcement, then those provisions cannot be seen as neutral and generally applicable, and thus are subject to strict scrutiny. Again, as Professor Hill mentioned, this is one of the claims made by plaintiffs in these sorts of cases. They cite exceptions, everything from life of the mother to rape to incest, even going on to IVF, and saying because the laws accept these sorts of things, they're not neutrally and generally applicable, and thus strict scrutiny applies. But of course, even under the Smith test or the Tandon test, which says that secular activity cannot be prioritized or treated more favorably than religious activity, you still need to meet the compelling interest test. My colleague here, Professor Georges, is going to speak more about that compelling interest test, but suffice it to say that even if a law is determined to be not generally applicable, they have a big hurdle with showing both a compelling interest in the protection of life. In particular, looking at sort of the Tandon case, what the court said was that when a comparable secular activity is treated more favorably, you trigger strict scrutiny. Again, that gets us right into what Professor Georges is going to talk about. But in my opinion, this strict scrutiny test is one of the bulwarks against these sorts of claims, providing broad exemptions. Another sort of, I guess, to walk through some of the things that states might say in response to free exercise claims. First, and I think importantly, is that free exercise is not a religious veto. Instead, it's just an exemption. As we talked about, it's not going to knock down a state's law. Second, under United States versus Seeger, there must be a sincere religious belief. Third, even if the religious belief is sincere, it needs to be compelled by religion. And then all of this means that even if the law is found to not be neutral and generally applicable, because one second, I will jump right back in. I will turn it over to our moderator, and then I will finish up in a bit. Thank you, Professor Moreland.
Sure. No, thank you, Erin. We'll come back to you in a moment. I will now turn it over to Michael Helfand to continue the conversation about the application of various religious free exercise frameworks to this context, and in particular, maybe to say something about how different religious traditions understand these kinds of claims and the strength of them.
Pleasure to be here with you this afternoon. So my goal for today in thinking about what exactly to present, I thought I might focus, especially given Professor Hill's note that nearly all of these cases in some way or another implicate either Jewish law or Jewish values. I thought maybe instead of doing a deep dive into the doctrine, the legal doctrine, I'd provide maybe a different kind of legal doctrine. I do my best to try to explain exactly how it is Jewish law gets somebody to the point where they see themselves as religiously obligated to have an abortion. In many of these cases, I think people are either skeptical or dubious of the claims. Some people even sometimes describe it as the tip of the spear, a political move in order to kind of push back against Dobbs. And as Ms. Hawley mentioned just a couple of moments ago, the reality is these kinds of claims have been out there for quite some time, and in particular with respect to Jewish law. So I'm going to try to take our listeners through, our viewers through a couple of thousand years worth of Jewish law, and we're going to play it like Name That Tune. I can do 2,000 years of Jewish law in 4 propositions. That's going to be my goal today. It's going to be inadequate. Everything I say can be contested and described as wrong, but in the main, I think hopefully you will get an accurate or authentic description of how Jewish law operates in this area. And for each of the 4 propositions, I'm actually going to cite a source, a Jewish law source, to give you a sense from the inside of exactly how Jewish law thinks about abortion, unless we want to go back to, should I keep on going?
No, go ahead and finish. Yeah.
Okay, sounds like a plan. Love it. Okay, so proposition number 1. The dominant view within Jewish law is that killing a fetus is not murder. Okay, and each of these propositions are going to build on each other. Now, if I were trying to explain to you the origin or source of this, so one of the most well-known sources of this view are 2 verses from Exodus. I hope not too many people feel like they're going back to Bible. Okay, whatever it might be. You're in for something you didn't expect today, listeners. So Exodus chapter 21, verses 22 through 23. I'm going to do the translation. If anybody would like to send a request for the original Hebrew, I'm happy to help with that as well. Quote, when men fight and one of them pushes a pregnant woman and a miscarriage results, but no other, and this is going to be the keyword, damage ensues, the one responsible shall be fined according as the woman's husband may exact from him, the payment to be based on a reckoning or evaluation. And then the next verse, but if other damage ensues, the penalty shall be life for life. Within the Jewish tradition, the damage that ensues, the word in Hebrew is ason, at least since the 3rd century has probably been translated or understood as referring to the death of the mother. And so here's kind of how you reconstruct the 2 verses as a result. If the woman is hit, there is a miscarriage, but nothing happens. There is no damage. Nothing happens to the mother. The result is a financial penalty. If, however, and this is the 2nd verse, if there is some sort of damage or some sort of damage ensues, i.e. the mother is killed, then it is a life for a life. And hopefully you can see how this works. The implication that it is only if the mother died that it is a life for a life means that if only the fetus is miscarried, no life has been destroyed, i.e., Jewish law based on this does not view the fetus as a life. Hopefully that worked for everybody as proposition number one. The dominant view within Jewish law is that killing a fetus is not murder. Okay, proposition number two. Jewish law only authorizes abortion when the mother's well-being is at stake. Okay, and here I'm going to give you a 2nd century text. This is a Mishnah, which is the kind of kernel or basis for the Talmud. And here's how this Mishnah, the 2nd century text reads. A woman who is having trouble giving birth, they cut up the fetus inside her and take it out limb by limb, because her life comes before its life. If most of it, i.e. the fetus, had come out already, they do not touch it because we do not push off one life for another life. And hopefully you see again what is happening over here. Here it appears what you're getting described is a late stage abortion, again in the 2nd century text, a late stage abortion. And note that it's only considered that you don't push off one life for another once the fetus has emerged, i.e., if the fetus has not emerged yet, it is not called, at least by this text, by implication, it is not yet called a life. And as a result, what you have the description is at that point, if the mother is having trouble giving birth, that's the language, makshel le'lev, for those who are Hebrew enthusiasts. If the mother is having trouble, it sounds like physical trouble giving birth, then you are authorized, that's at least what the text sounds like, you are authorized in order to protect the well-being of the mother to go through with an abortion, even what sounds like a late-stage abortion. Okay, we're halfway home. Proposition number three. This is where things, I think, get surprising for those who don't have a familiarity with Jewish law. The authorization to abort a fetus out of concern for the mother's well-being typically generates an obligation to abort the fetus. I think this is what people find particularly surprising, that in many circumstances, it's not just that you can abort, but that you ought to under Jewish law. Jewish law might even say must or are required to abort. And to do this one, I've selected for you a 13th century text. This is Maimonides. And here's how Maimonides formulates the issue. Quote, "It is a negative commandment that one should not protect the life of a rodaif, a pursuer." What's a pursuer? Imagine somebody chasing somebody with a gun. They're threatening that person. That person is pursuing somebody in order to kill them. And so Maimonides notes, it's a negative commandment that you should not protect that person's life because they're chasing somebody else with a gun, so to speak. For this reason, this is what Maimonides says, the sages ruled that in the case of a pregnant woman in a dangerous labor, it is permissible to dismember the fetus in her womb, whether with a drug or by hand, because it is like a pursuer, pursuing her to kill her. However, once his head has emerged, one may not touch him, as we do not set aside one, he uses the word nefesh or soul, one soul for another soul, and this is the natural way of the world. So note what we have over here. The fetus is conceptualized by Maimonides as somebody chasing, endangering the life of the mother, and as a result, it would violate a negative commandment to say, no, 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 we want to protect the fetus because the fetus is viewed as a pursuer, and therefore, because the abortion in this circumstance would be to protect the well-being of the mother, again, he's describing it as physical well-being, you would be violating a negative commandment under Jewish law to protect the fetus because of its status as a pursuer. Okay, proposition number 4, this is it. And I think this is the part where you really begin to see how Jewish law generates all of these different kinds of permutations of potential conflicts with abortion restrictions. The dominant view under Jewish law, certainly probably in theory and certainly in practice, is that the category of well-being of the mother encompasses not just physical risk to the mother, but also non-physical risk to her well-being. And this is an issue that's come up in many different contexts. The most famous context in Jewish law is with respect to children who have Tay-Sachs, fetuses that have Tay-Sachs, and whether or not this has been a question. This is a disease where the child will inevitably die quite soon after birth. And it's the Tay-Sachs disease is carried a much higher percentage within the Jewish population. And so Jewish law authorities over the years have been asked whether or not you can abort a baby that has Tay-Sachs because of the potential mental harm to the mother. And that's been the big debate. Some have said, Rabbi Moshe Feinstein, one of the great Jewish law decisors in the United States in the 20th century, his view was no. If even under such circumstances, you may not abort. But the dominant view, one expressed by Rabbi Eliezer Waldenberg, a Jewish law authority in Israel, who also has had a lot of influence in Israeli hospitals. His view was actually under such circumstances that constitutes well-being of the mother within the formulation of Jewish law, and therefore all the Jewish law rules would apply. If you're piecing together propositions 1, 2, 3, and 4, and you haven't quite fallen asleep on me yet, what you have ultimately is you can see kind of pretty clearly what a Jewish law religious liberty claim might look like. You might be dealing with someone who discovers, I don't know, late in a pregnancy, that they are carrying a baby that has Tay-Sachs, for example, and that the potential harm to the mother to carry the baby that will inevitably die is so significant that a Jewish law decisor would say, no, this is someone who, where giving birth is going to cause some sort of harm and therefore falls within the well-being of the mother, is a threat to the well-being of the mother. The mother, therefore, not only can abort the fetus, but you might even get someone rendering the view that they ought or must abort the fetus under such circumstances. And if you're in a jurisdiction that had an abortion restriction that prohibited late-term abortions and had other exceptions, both as Ms. Hawley and Professor Hill have already mentioned, you might get a religious liberty claim that looks something like a Tandon claim or like a Fulton claim, where there are other exceptions. Here you have a religious requirement in order to have the abortion. And as a result, you might have what certainly looks like your kind of garden variety religious liberty argument. I say one last thing about this. It's not surprising, given kind of that Jewish law has had this view for quite some time. Jewish law, American Jewish organizations and institutions have been making these claims about religious liberty with respect to abortion for quite some time. They've been showing up in amicus briefs before the Supreme Court at a minimum since the late 80s. There's been a little bit of a switch or a flip-flop back in the day. It was more, I would say, theologically conservative groups that pushed these religious liberty claims. They've now been taken up, I would say, more so by American progressive Jewish organizations, but their logic and their inner workings are largely the same. The Jewish law sources that all these organizations quote look nearly identical, and I suspect as a result, given how long and how far back the lineage of these Jewish law views go, we'll continue to see these sorts of conflicts going forward.
Thank you, Michael. Erin, I know you were cut short before, so if you want to just conclude with a minute or two to wrap up what you were saying, and then I'll turn to Shreve Gerges.
Absolutely, thank you. I think my 3-year-old asserted her first free exercise right to apple juice. So my apologies. So the only thing I'll say before turning it over is that with respect to these claims that Professor Helfand laid out, you do have the question of whether even if there is a right, free exercise right asserted, whether it meets the compelling interest test. And so states have rightfully asserted the life of the child as a compelling interest that would work to uphold whatever that statutory pro-life provision is. The second thing I'll mention, and I already alluded to this, is that those sorts of claims would only be as applied to a particular woman, or perhaps if you're thinking about a class action, maybe a church, but even that might be a stretch. And I think that's why we're seeing more of these Establishment Clause claims, at least in the literature. But the problem with the Establishment Clause claims is that the argument goes that these pro-life laws are based on Christian morals, and that is an affront to the Establishment Clause. Of course, a lot of our law is based on moral of one variety or another. The court has rejected the Lemon test, which says there must be a primary purpose for a law, a primary secular motivating purpose. So I don't think those Establishment Clause claims are going to get off the ground, but that is an effort to make a sort of more broad brush challenge to these laws.
Thank you very much. Sharif Gurgis, last but not least, I was wondering if you could respond to the other things that people have said, but in particular, as beginning with Professor Hill's presentation and carrying on, there's been a really kind of fine-grained issue here about how the strict scrutiny framework applies, comparator secular exceptions, and so forth. And so if you could perhaps say something about that against the background of this issue.
Sure. So first I want to say thanks for including me. This is a great panel and I'm super excited to be part of it. I do think if the procedural hurdles are cleared, and I agree with Erin that the procedural hurdles are significant, if they're cleared, I do think there will be some cases where strict scrutiny is triggered because the claim will be sincere, the burden will be substantial. I actually don't think it has to involve the claim of a religious duty, but Michael has shown that that could be cleared anyway. And so strict scrutiny will be applied, which means the state has to show that the application of the law to the religious plaintiff is the narrowly tailored means of serving a compelling interest. And the argument that they can't do that has rested entirely on the fact that all of these laws make some exceptions. All of them make exceptions for the life of the mother. Some of them make exceptions for serious bodily injury to the mother, for lethal fetal abnormalities, for cases of rape and incest, maybe for very early abortion, and for IVF. So the question is, if you've made all those exceptions, can you really insist on applying it to the religious claimant, or don't you have to flunk strict scrutiny? The main argument then is really about over or under inclusiveness, the idea that you're not pursuing your stated interest at all costs. And there are lots of cases saying under inclusiveness is a problem under strict scrutiny. But I don't think it's always fatal. And in fact, there are cases explicitly saying it's not always fatal. There's a case called Williams v. Lee, where the Chief Justice had an opinion expressly upholding a law that he admitted was under inclusive, under strict scrutiny, and string citing half a dozen other cases that had done the same. So, and I actually think that has to be right, because otherwise there'd be you couldn't clear strict scrutiny even for your homicide laws, because all homicide laws make some exceptions for self-defense, et cetera. And so then we'd be stuck saying you have a religious liberty right to honor killings and child sacrifice if an Aztec moves into town. And that can't be right, even as a hypothetical matter. So what's going on? I think what's the case law suggests is that under inclusiveness is a red flag, but it's not itself fatal, because the question is whether it points to or causes a deeper problem that does doom you under strict scrutiny. So I'm going to go through 4 or 5 potential deeper problems and say why I think in most cases, at least, they won't be present in these cases, but we can talk about outlier hypos. So first, it could be that the existence of exceptions proves that the interest that you state is just pretext. That was the case in Lukumi, where a city ordinance had banned the ritual slaughter of chickens officially for health and aesthetic reasons. And the court said, those aren't really your reasons, because if they were, you wouldn't only ban it when it's used in a ritual. And that limitation showed that what you were really motivated by was hostility to the Santeria minority religion in your community. I don't think anybody could suggest that there's such a gross under-inclusiveness here that we can only imagine religious animus motivated the laws. To have a hypo like that, you'd have to imagine a case where, for example, a state went from banning no abortions at all to banning abortions on any, to allowing abortions only on Saturdays, so that the Jewish plaintiffs couldn't make it because they're the only ones who can't get an abortion because that's their Sabbath. We've got nothing like that here. But the second possible thing is that even if your asserted interest is sincere, if your law is so potted with exceptions that it doesn't really advance that interest, you're going to flunk strict scrutiny. We're not going to accept a burden on religion or speech or another right for the sake of no real benefit. And that was the case in a case called Smith versus Daily Mail, where the court said that if you're saying that we need to protect juvenile privacy, the privacy of juvenile defendants, by barring print media from publishing their names, well, by allowing electronic media to publish their names, you're so undermining your interest that your law is not really going to achieve privacy for those defendants. So you're going to flunk strict scrutiny for that reason. Again, I don't think that's going to be an issue here, because laws that that punish abortions, there's no question that they're going to, in fact, reduce the incidence of abortions, or at least that's something that's going to be taken for granted in this setting. So it's not that the law doesn't advance its goal at all. A third possibility is even if the interest you state is sincere and your law really does advance it, the existence of exceptions proves that there are less restrictive means, which is another way to flunk strict scrutiny. And that was the case in Tandon, the COVID era case involving a regulation where California had put restrictions on social gatherings, but it had barred certain religious social gatherings while allowing certain secular gatherings as long as they observed certain precautions like wearing masks. And the court said that's no good under strict scrutiny because there is a less restrictive means, which is allowing the religious gatherings to use the same precautions that you are allowing secular gatherings to use. Now, there's a sentence, just to finish that thought, I don't think there's anything like that in this case. Nobody doubts that a law that permitted more abortions would undermine the state's interest in protecting fetal lives. So there's no less restrictive means. Any further exception would further undermine the state's goal. There's a sentence in Tandon that I think is misread in a lot of these arguments. So there's a sentence that says, California needs to show that the social gatherings that are secular are less risky than the religious gatherings in order to satisfy strict scrutiny in this case. And so a lot of people take that and say, well, in this case, you can't really suggest that secular abortions sought for secular reasons are less harmful to your asserted interest in fetal life than religiously sought abortions, and therefore you flunk strict scrutiny. But I don't think that's right. I think it's very clear from the paragraph in Tandon where that sentence appears that it's saying that in that case, the California had to show that the religious gatherings were riskier only because that was relevant to the least restrictive means inquiry. Whereas here, no one doubts that a less restrictive law would undermine the state's interest to some degree. Okay, so the final possibility, even if your interest is sincere, even if your law really does advance it, even if any less restrictive law would advance it less, maybe the very existence of the exception shows that your interest is not really compelling. At a first pass, it looks like Dobbs undermines this objection because Dobbs says that states are free to decide if and when the prenatal life gets any or all of the rights of personhood, including the right to live. So if the state is allowed to think that the prenatal life is a person with the right to live, it's surely allowed to think that protecting that life is a compelling interest. But then the argument could be, well, even if in principle you're allowed to think that, you, particular state, Indiana, or what have you, don't really think that the interest in fetal life is compelling, as proven by your exceptions. If you thought it was compelling, you wouldn't have any exceptions. And here, I don't think that that's supported by the case law either. I think what the case law suggests is that in those cases, you at least have to show that there's some qualitative difference between the exceptions you're allowing and the exceptions you're denying to rebut the inference that you must not really think fetal life is compelling. And in this case, I think in most cases that I've come across, I think the state will be able to do that. It'll be able to say, look, there's an interest in procedures needed to save the mother's life or health because that's a very serious, in fact, compelling interest of its own, preventing the peculiar kind of qualitatively different kind of psychological trauma, as the state might see it, in carrying a pregnancy to term after rape or incest is a similarly serious interest. They might say that their own public interest in fetal life is less at stake when it comes to, for example, forcing somebody to keep embryos on ice in the IVF context. And then they can say, look, and it would undermine another compelling interest. In fact, it would undermine a constitutional right to compel people to implant embryos that are currently on ice. And there might be serious enforcement issues or something in trying to prospectively prevent people from creating embryos that they don't intend to implant, since the main remedy would be to try to implant them, which you can't do without violating people's rights. So they might, in this kind of way, suggest that the exceptions that exist are categorically different, involving either less harm to the state's interest in one or two of the cases, but in most cases, there would be a significant new qualitatively different harm in regulating those cases that isn't present when they regulate the religiously motivated abortions. And I think under the doctrine that would be sufficient to clear strict scrutiny to show that the state's interest is sincere, it's actually advanced by these laws. Any less restrictive law would advance them less, and the existence of the exceptions are adequately explained so that you can't infer from those exceptions that the state's interest isn't compelling or it doesn't think it's compelling.
Thank you very much. So we have about 15 or so minutes left. Again, invite people to submit questions through the Q&A function at the bottom of your Zoom window. But for now, I thought for a few minutes at least, have some time for the panelists to respond to each other. In particular, Jesse, you had the burden of going first. So now I will invite you to say anything you'd like in response to some of the arguments that have been made on the other side from your own position.
Thank you. Yeah, I mean, I have lots and lots of thoughts, but I think I'll try to just put a couple of them out there. I mean, I think just responding a bit to Sharif, I think it's a very interesting take. I think it's not supported by the free exercise case law at all. So, I mean, I think there are, or not by the current state of free exercise case law. I mean, there may be strict scrutiny applications in the context of other doctrines like free speech and so on that do not follow quite as strict an approach to strict scrutiny. I don't think you're going to find very many cases that are free exercise cases. I mean, Tandon, I'll come back to. I don't think that would be willing to give the least restrictive means ground on these abortion restrictions. But I will say, I think if even one exception is enough to undermine the sort of neutrality, general applicability, even like a hypothetical exception, like the existence of the possibility of exceptions, as in Fulton, I think it also raises questions about abortion bans and the compellingness of the interest behind them. I think on the least restrictive means question, I'll just say, I think that this is the kind of thing, and again, we're talking about strict scrutiny land, so it really matters very much what the facts are and what the exact nature of the challenge is. But I think that there very well may be questions about whether denying an exemption, for example, to a drawing on some of Michael's comments, a Jewish pregnant woman who is claiming she needs an abortion due to severe mental health distress or severe physical conditions, but that is not entitled to an exemption under a state abortion ban, whether that really the state can really claim that it is advancing its interest in life at that point by the narrowest means possible. I think flat out abortion bans do not necessarily reduce the number of abortions. For example, I don't think that we can take that for granted. That has not been the evidence, actually, and that they do not necessarily advance maternal or infant health for that, or they do not. States with severe extreme abortion bans actually have higher rates of infant and maternal mortality than states without them. So again, there are questions about whether the state is always advancing an interest in life when it is imposing a ban like that by the least restrictive means possible.
Erin, I guess I'll come back to you as well, see if you have any thoughts or reactions to others' comments.
Sure. I think I would like to echo what Professor Georges said about the exceptions can't swallow the narrow tailing rule or absolutely mean that it's not met. Otherwise, as Sharif mentioned, you wouldn't be able to have murder laws because, of course, there are self-defense exceptions. And just the fact of an exception doesn't mean that that law would fail strict scrutiny if you had some sort of religious claim, like an honor killing or different sorts of religious practices we've seen during the medieval period. So I think that can't be the state of the law, or else we would have to have a sort of fundamental reworking of basic laws that we take for granted. I think when you're talking also about the interest of the state in life, Perhaps, and certainly there are ways that states could advance those interests more fulsomely by providing more support to women, both in pregnancy and beyond. But the reality is that with an abortion, a child's life is taken. And so I think that is a compelling state interest.
Michael, excuse me, I'll transition maybe here to the some questions from the audience. In particular, there's one for you, for Professor Helfand. Is there any specific Torah citation that implies or states Mosaic law requires an abortion to prevent a non-physical risk to the well-being of the mother?
I really hate having to prove a negative, but and the word Torah is an ambiguous term, I think, used in different ways by different folks. But let's just say that if you're looking for like a biblical reference, you're not going to find it. It is a view that certainly has, that is, I would say, of more recent vintage. And as a result, it's an interpretation and expansion of the having mother's well-being, having difficulty giving birth. And I would describe it as an attempt to argue from the underlying principle, if the principle is well-being, as over time we've learned more about non-physical well-being. Jewish law authorities have used the underlying logic of the older text to expand the category. But there's nothing there like from the 2nd century, 3rd century. And when I say nothing, I'm sure somebody is going to put in the chat something, but nothing comes to mind right now that expanded the category to non-physical well-being, I would say, early on in the Jewish legal tradition.
We have a question following on Sharif Gergis's presentation. How does Professor Gergis's argument about least restrictive means hold up in the 49 states that allow the destruction of fertilized embryos in the IVF process? If the state claims, as Indiana does, that its compelling interest attaches at fertilization, is the claim that the state has a compelling interest in promoting fertility that is sufficient to justify killing unborn children, or is Professor Gergis's view that a fertilized embryo is not a human life? Or is the claim that an exemption from the abortion ban for destruction of fertilized embryos in the IVF process is least restrictive means? And there's some other parts of the question, but that's basically it's about the exception for destruction of fertilized embryos.
Good. Yeah. So I want to say something about that first, very briefly, to Professor Hill. I agree that the free exercise doctrine has been very aggressive. I think it's been aggressive on the trigger for strict scrutiny and the sort of existence of a single hypothetical exemption and so on reflects that. I think even in the most maximalist opinions, like an opinion by Justice Gorsuch in a vaccine mandate case, I think a dissent from denial, where he has a very low bar for triggering strict scrutiny. He allows that the compelling interest inquiry might cut in favor of the state in that case, allowing medical exemptions for abortion or from vaccine mandates, but not religious ones. But okay, but on the IVF question, I love the question because I used to think this was the knockdown argument against the state, and that and the first time I talked about this, I said I don't really see how the states could respond, and I was so excited. This shows my intellectual capaciousness, and I'm not totally predictable. You can't box me in. And then somebody pressed me on exactly what kinds of regulations I have in mind that the states should be making of IVF that are no qualitatively different from the religious exemptions, and actually ran into some trouble. So it's less about whether, and by the way, the part of the question is what I think of the fertilized egg, the embryo, et cetera. I don't mean anything of what I'm saying to reflect my policy views. I don't like some of these laws for a number of reasons, some of the exceptions that are drawn and some of the lines that are drawn. I used to think the IVF line was motivated mainly by basically politicians not wanting to upset their extremely rich constituents who want to use IVF, and that this is okay. All right, but the local proximate concern I had was that there's kind of practical obstacles to enforcing or to having a meaningfully enforceable law on these fronts. And I might be proven wrong, but just to give you an example, the state might say, look, there's a difference. Our interest is different in preventing the termination of a life that's already en route to development to the next stage versus forcing people to keep an embryo on ice indefinitely. But then and then you could say, well, they could compel the implantation, but compelling the implantation would definitely be unconstitutional requirement for people to undergo a medical procedure without consent. You could say, well, we're going to ban prospectively the selection of embryos because people only select in order to discard the ones they don't like. But if it's, and this is partly an empirical question now, if it turns out that most of the selection happens not because people don't like, but because they're trying to figure out which embryos are most viable and most likely to survive a pregnancy in order to increase the chance that the process works, then that might cut differently. So the question is not, does the embryo somehow count for less, or can the state plausibly say it counts for less when it's outside the womb versus in the womb? It's more of what's the regulation that we're imagining that's relatively on all fours with the regulation of the religiously motivated abortion that the states are failing to do on the IVF front. And it could turn out there is such a thing, but that's the thing that I was thinking was less obvious than I initially thought.
So can I just say, I mean, Louisiana has a law that you cannot destroy the embryos. You have to hold them or see that they're implanted. And, most people who have IVF my understanding is that folks who have IVF in Louisiana have their embryos shipped out of state, but, a state can have a law, right? And I'm not sure, and as a matter of fact, Italy for a long time, I think had exactly that law as well. I don't think, though, that enforceability issues are generally understood to be an exception to or a response to an otherwise, failing strict scrutiny analysis. So, I mean, something that can counteract strict scrutiny in that circumstance. That would be my understanding. But
so that's really helpful. And I agree on the Louisiana thing. I was thinking that's not about enforceability. In that case, other states might say, we have a different interest in keeping an embryo indefinitely on ice where 99% of them will never be able to advance to the next stage of development on the one hand, versus preventing the termination of a prenatal life that is basically already in the process of maturing to the next stage and has some meaningful prospect of growing into maturity. Again, I'm not saying that reflects my moral or policy views. I'm just thinking that's a qualitative difference that a state could reasonably see. And the enforcement concern I have on the forced implantation is not just like, it'll be hard to do, administrability or something like that, where I agree with you that wouldn't suffice in a free exercise, but that it would actually undermine another compelling interest, if not a constitutional right, against forced medical treatments.
Let's see if we have time for one more question, at least. From the audience, is there a world in which the Supreme Court revives Smith in these cases? If so, would there be a principal ground with which it can reconcile this with more recent free exercise doctrine, I assume referring to Tandon and Fulton, cases like that, without the appearance of having a Smith for thee but not for me approach? If anyone wants to tackle that. Go ahead, Erin.
Sure. So if I'm understanding the question right, it's whether the Supreme Court could sort of revive Smith in a context in which the opponents of Smith lose by finding a right to a free exercise right to abortion. So if I'm understanding that correctly, I think that is that overruling Smith would be consistent with both Tandon and Fulton. Fulton, of course, dramatically narrowed the scope of laws that are considered neutral and generally applicable. That the same for Tandon. So I think that the overruling of Smith would be consistent with those cases. Whether the court would do that, I don't think it's consistent with how the court has looked at the compelling interest test in other cases. So I would think not, but it is an interesting question.
Anyone else want to respond to that? If not, we're almost at our time, but I thought I would give everyone just a minute or less than a minute, so we don't go too far over the hour, just with any concluding thoughts. So perhaps I'll go in the reverse order from which we started. So start with you, Professor Gerges, if you have any brief concluding thoughts.
No, I've talked too much. I've really enjoyed this, and I really appreciated the comments. Yeah.
Michael Helfand.
I'm still trying to get Professor Gerges to tell me if he thinks fraternal order was wrongly decided, and I didn't get my question in, so I cede my time to him to answer the question.
Good. So I think there's two ways of reading fraternal order of beliefs, and I won't explain it for people because I have less than a minute, less than 45 seconds now. One way is to read it as saying, actually, what the differential policies show is that there was a less restrictive means. Another way of reading it is as saying, and I think that's totally consistent with what I've been saying, a more complicated part would suggest, actually, no, the problem was just the mere existence of the secular exception showed they were devaluing religion, and that devaluing itself is per se unconstitutional. I think the only way to avoid making that entail that every law with exceptions is a violation of free exercise is to say that in that case, the interest in making the secular exception, but not the religious one, was not weighty enough. Now, I don't know if that doctrinally that means the exception has to serve a compelling interest or it just has to serve a really serious or non-trivial interest. And Alito, in that opinion, thought that the health interest asserted was trivial. But I think those are the only charitable readings of my old boss's opinion, and that if we read it as saying something more per se, it would be clearly inconsistent with the thrust of the court's doctrine.
Erin, Hawley, any concluding thoughts briefly?
None from me.
Okay. Jesse, anything from you?
I'll also cede my time. Thanks.
Great. Well, I want to thank the panelists very much for this spirited and diverse discussion, raising a lot of different issues from different perspectives about this issue of free exercise and abortion. We touched only very briefly on the Establishment Clause issues that a couple people mentioned, so maybe we'll do another webinar on that sometime. I want to thank Marco Lloyd and Nathan Kaczmarek at the Federalist Society for their good work helping to organize this. And again, once more, thanks so much to the panelists for so generously sharing some time this afternoon with us on this important topic. And with that, we are adjourned.